The defendant opens with "This is my life," instantly framing the stakes as deeply personal. But the judge doesn't entertain the emotion for long. Instead, the response is sharp, grounded in responsibility, and cuts straight to the issue of unpaid child support. You can already sense the imbalance of control here. The judge sets the tone early, firm, direct, and unwilling to be swayed by sympathy alone. It's a powerful introduction that establishes conflict, authority, and the emotional weight of what's about to unfold.
This is my life.
I understand that, sir, but you're asking me questions I can't.
27 days incarcerated for no reason.
No, there is a reason. You pay your child support. Now, if you want to keep going, I can do something else with the bond. But I think we're done here.
The prosecution drops a number that completely shifts the atmosphere: 192 calls to the victim. That's not just excessive, it's alarming. The defense tries to pivot, questioning the substance of those calls. But the judge isn't interested in technicalities. The sheer volume alone signals a violation of trust and court conditions. You can feel the tension rise as the judge processes this information. Then comes the decisive blow. The bond is raised significantly, and communication privileges are stripped. This is where the courtroom dynamic hardens, and the consequences start becoming very real for the defendant.
Your name, sir?
Deontay Jones.
Thank you.
Your Honor, I was just appointed to this matter. I do not have any body cam or video footage, which I'd be requesting, so I'd be asking for an adjournment.
April 9th. Okay. I'll adjourn this to April 9th, 2026, 9 a.m. That's the bond.
The defendant's bond is currently set at 45,000 with a 10% provision. At this point, I was going to be requesting our original request of $50,000 cash surety. Mr. Jones, since being arraigned on March 15th, has made 192 calls completed to the victim.
192.
And I suspect that number may have grown since yesterday because that was when the most recent set of calls has happened. We've been having a hard time keeping up with the amount of calls that he's been making. So at this point, I'm going to be re-requesting our original request. This case is also occurred when Mr. Jones was on probation out of the 22nd Circuit Court for domestic violence for different victims, along with larceny in a building. And at this point, I have concerns given that he's made this significant number of calls to the victims from his pen to her listed number. And I'm going to be requesting our $50,000 cash surety original request along with his phone and text privileges being revoked after the judge blocked her number as well.
Just a short response, Your Honor. What I hear are a number of calls, but I don't hear any of the, I guess, the substance of what those calls are about. So I certainly would be asking that court would at least temporarily stop his.
That he's not supposed to have contact at all.
The courtroom unexpectedly shifts into a lighter, almost human moment. The judge reacts to an attorney leaving the case, and suddenly there's humor, sarcasm, even laughter. It feels like a rare glimpse behind the formal curtain of the legal system. But don't mistake this for softness. This moment actually highlights the judge's personality and control of the room. It's a brief pause in the storm, allowing everyone, including the viewer, to breathe. Yet, beneath the humor, there's still authority. It's a subtle reminder that even in serious settings, human emotion still finds its way through.
It doesn't matter what he's talking about, really. But go ahead, I'm sorry.
No, that's understood. I would like to get a copy, be able to review them prior to addressing them further, but I think taking away his phone privileges is enough rather than raising his bond.
That's a significant amount of calls, a significant amount of connected calls. And the very fact that he's on probation on a DV, he understands, certainly understands what his bond conditions would be regardless.
Mm-hmm.
I think he would have more of an understanding of it. I'm going to grant the people's motion. The defendant's bond is reset at $50,000 cash surety. We'll get the message. And also his phone privileges as well as texting privileges are hereby ordered revoked. Thank you.
Thank you.
Marion White.
Okay,
Your Honor, discovery is complete in this matter. I'm going to set an exam. I believe Mr. Childers is going to no longer be on this case because, well, he's leaving the office, but we're going to request an exam.
why do you have to say it out loud and make us all sad?
Send us some
Why-
great, no,
why-
why so much? Everybody knows. I wasn't trying to make anybody sad, Your Honor.
Oh, I'm sad.
I am too, but I know he's moving on to bigger matters. So,
You don't have anything to say?
it's a hallmark moment, Judge.
You're making me sad though. You did this before to me,
I know.
so. It's okay. I have the ability to issue warrants.
I understand.
The defendant admits to a relapse involving cocaine laced with fentanyl, and suddenly this isn't just a legal issue. It's life or death. The defense tries to frame it as a one-time mistake, but the judge sees a pattern forming. Then comes a chilling line: he's either going to end up dead or back in jail. That statement hits hard because it's brutally honest. The request for bond reinstatement is denied, and you can feel the weight of that decision. This moment stands out as raw, real, and unforgiving.
Fair enough, Your Honor.
Will the people have their witnesses, what they doing? People have their, no. Yes,
Because I don't know.
We'll have it.
Really next week, is inheriting this case from.
got it.
If Mr. Burgess has a vacation that he absolutely cannot miss the week of the 13th, if there's any way we could set this for the 20th.
I can set it for 21st or 28th, which one?
21st is fine, Your Honor.
Preliminary examination in person will be set for April 21st, 2026, 9 a.m. before Judge at Washington. Get it out.
You need it again? I'm going to talk it for you.
Bond will continue as time. Thank you.
Name for the record, please.
Khadijah Kaba.
That's right. Go on.
Your Honor, all discovery is in. We'd ask the court to set this for preliminary exam. And I have a very simple and brief bond request before we conclude.
People have their witnesses available the 7th. Preliminary examination in person will be set April 7th, 2026, 9 a.m. before Judge Perry.
Thank you, Your Honor.
That's the bond.
Your Honor, my client previously posted bond, but because this case turned into a violation of probation in 14B, she is held without bond in 14B. So I would simply ask the court, so she can get credit for her jail time, to add maybe another $100 bond, so that while things are being worked out,
Or bound to that in this case.
I see it as, I think, a 30,000, 10% that I believe was posted. But because, again,
Posted the cash surety, she did.
yes. And it looks like she's being held at least until,
Bond amount will be set in the amount of $50,000 cash surety.
thank you.
Thank you. Choice vote. We received a confirmation test. Did you see that?
Yes, Your Honor.
If cocaine was confirmed positive as well as the fentanyl.
Yeah, I'm assuming it was a mixture, Your Honor.
Yeah.
Your Honor, first, let's deal with the issue of ECC. I do not have complete discovery yet. I do have some, but I have had an opportunity to discuss the matter with Mr. Chabalowski. We need a week to further explore the matter. And also, Mr. Chabalowski informed me that there are potentially additional charges coming against this defendant, probably a misdemeanor, but there are possibly. And that we'll need to factor that into our discussions.
All right. So you want me to adjourn it?
The 9th, I think you said, was the next date.
Just a week. Well, I have the 2nd or the 9th.
When I said the second a minute, you said that wasn't available, I thought.
Pardon?
On my other case, I thought you said the second wasn't available.
Only because I think we had to, there's a video read.
Oh,
We had to do a read.
oh, Mr. Bruce will be out. He should be out as soon as they find it. Well, look, I should.
I know,
Yeah,
not me.
right.
I had to go.
Yeah, 2 weeks to find a tether is a little bit extreme, Your Honor, but I understand.
So-
It's Wayne County. Yeah.
But I can go to the 2nd or the 9th.
I prefer the second, Your Honor.
Probable cause conference will be adjourned April 2nd, 2026.
Your Honor, I would like to address the issue of bond.
Yes.
Okay, Mr. Swope had posted bond. I don't remember if it was a PR bond or not, but he was out. Mr. Swope admittedly has a drug problem and was being treated with Suboxone. And as long as he was taking the Suboxone, he was not taking any other drugs. However, he had an accident, was it?
Yeah.
They took what he had an.
So I got out and I didn't have my insurance in time. So
That's right.
So
Okay. Right. So when he got out of jail, he went to get a prescription for the Suboxone. They wouldn't honor his insurance because it had to be reprocessed because he was in jail. And he admitted that he slipped. And for the one time, the cocaine, which had fentanyl in it, obviously he was using it for the cocaine. Your Honor, we would ask that you would consider reinstating his bond. He is back on the Suboxone, or would be if he wasn't in jail. And as long as he takes the Suboxone, he is drug-free, otherwise drug-free.
I'd have to see some proof that he is in treatment, that there's some programming. Because he's got a deadly cocktail that's come back twice. And so he's going to end up dead or he's going to end up in jail. I'd rather have him in jail.
I do have proof though.
Can you get that to me?
Yeah.
Okay. Go get it to me.
The defendant tries to explain years of unpaid child support, offering context, excuses, and even partial payment, but the judge remains unmoved. There's a clear focus on accountability, especially when the judge reminds him that those children survived without his support. The back and forth becomes almost exhausting, with the defendant pushing for leniency and the judge standing firm. Confusion about legal procedures only adds to the tension. And then it all circles back to where it began. This is my life. But this time, the judge delivers the final word with authority, closing the case with a powerful, unshakable stance.
So at this time, I'm going to deny us. Bond will continue as denied.
Oh, sorry, Judge. Carrie Angie for the people.
Thank you.
Assistant Superintendent Nick Bukovich for Mr. Matthews.
All right. Your name, sir?
Matthews.
All right. What are we doing?
Mr. Matthews indicated he'd like to speak to you, Your Honor. I did advise him against this. However, he would like to speak to you at this time.
Speak to me?
Yes, Your Honor.
For what purpose? What do you want to say?
I have evidence in my case. I wrote a letter also and submitted information into
I
the case.
see that, but what do you want me to do with that?
Well, this case is for year 2010 through 2013 for a total of $58,000 in child support. So for those 3 years, it's calculated up to $1,100 a month. At that time, I was on food stamps, and that amount would not have been an accurate child support amount. Now, as far as the warrant, I went to court in Tennessee in September 9th of 2021 on this matter, and a judge ruled on it. So I wasn't aware of a warrant or anything like that. I've sent certified mail.
Told all of this to your attorney because
I have.
but I can't do anything.
I have. My attorney refused to work for me as I needed him to.
Oh, so with your law degree, you were going to try to tell him what he needed to do. And
It was-
some of that stuff he couldn't do.
Forgive me,
So
Your Honor.
it's not working for you.
Forgive me, Your Honor, for addressing the court, but it's not submitted any information that would get me home to my family. I had my employer has advanced me $10,000 towards my bond, get home to attend to my business on Monday.
I did send information that was provided to Ms. Gaines by Mr. Matthews Lights to AG Williams this morning. Obviously, AG Williams is not the attorney on today, but that was the attorney on the docket. So that's who I sent this information to and communicated with earlier this week about Mr. Matthews.
So you actually did your job, right, Mr. Buckovich? But nobody appreciates it. I got you. Anything else you want to tell me?
Yes, sir. I was extradited from Texas. From here, it's been a total of 27 days that I've been incarcerated. Um, the letter that I wrote to you explains a lot more in detail.
Right.
I have $10,000 for my bond so that I can be released to get back to work. My wife,
Law requires 25%. So if you're at 58, I'm gonna be somewhere around 16, 17,000.
14,500.
I have your bond in this case set at 16,80462.
Yeah, the numbers that were submitted for the total is about 3 different numbers. And I'm not sure which one is correct. I received a letter in the mail.
Well, if you paid the 16,000, it's gonna go to where support should be anyway. So I'm not changing the bond.
Right?
Anything else?
No, sir.
What do you want me to do with this case?
Yep.
I just opened that to the floor, I guess. I don't.
You asking me? You asking me? Like,
Huh? Whoever wants to answer me.
well, I believe that the 10,000 should be accepted
Okay,
home to my wife and sons.
10,000. Then you need to come up with about 6,000 plus more.
This case is between the years of 2010 and 2013.
Okay, and somehow those children had to survive without you paying your child support.
It was only 3 years. My son is 30 years old now,
Okay, and it's owed.
and I want to pay it, sir. I do want to pay it. Can I start with the $10,000?
We will take the 10. Then you gotta come up with 6. I told you that. I mean, I'll keep repeating myself as long as you want to keep repeating yourself. I don't have a problem. I got all day.
I mean, you do send this form.
When is the court date?
He'll give it to you. Yeah, I can do it.
I've spoken to him one. Whatever he's spoken to him.
What? We wait a little longer, he'll probably have 12,000.
What?
Yeah, the longer we go. Just a lot more money. I'm thinking.
This is the offer we talked about on Tuesday, when we were in jail. We're waiving up. If you pay the certain portions down, they will reduce the charge.
To do that. Judge.
Wow.
Suspects, sure.
You'll be waiving, Your Honor.
Pardon?
You're waiving, Your Honor.
Okay. Thank you. That is almost lunch. Sir, you're waiving your right to a preliminary examination?
Yes,
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
yes.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
When would the hearing be?
Pardon?
When would the hearing be?
Soon. I will set a date.
Okay.
I mean, this isn't a negotiation. You want to waive or not?
Well, I
You
do,
want to waive or not?
I do, but I don't understand all the court proceedings because
Okay, and that's why
I'm not a criminal.
to listen to you.
He's been doing this for 2 years. And I'm not a criminal.
2 years long. Do you wish to waive your preliminary examination?
Yes.
You will also waive?
Yes, Judge, thank you.
I thought everybody was All right. Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr. Buckovich, with your 2 years experience, can you do this part? Go ahead.
To waive formal reading information and stand mute as to the charges.
Defendant having waived formal reading, stating mute, court will enter a not guilty plea. Pre-trial in this matter will be set.
1:30, Judge Slay.
Here's your date, April 9th, 2026, 1:30 before Judge Slay.
I have one question, Your Honor. If I pay the bond to get out, I reside in Tennessee. That's where my home is. Will I be allowed to go home and then come back to court?
If you pay the bond, you're gonna have to stay in Michigan until the court gives you permission. So now, this having been waived, Judge Slay would be the one that you'd have to ask.
Well, where would I stay here in Michigan?
Where would you stay? Well, we're providing accommodations at this point.
Well, once I get out.
I don't make hotel reservations. I don't push. Can't stay at Childers' house. This thing.
Listen, this is my life.
I understand that, sir, but you're asking me questions I can't.
27 days
with.
incarcerated for no reason.
No, there is a reason. You pay your child support. Now, if you want to keep going, I can do something else with the bond, but I think we're done here. Thank you.
This is my life, man.
Yes, I know. And you've taken part of mine that I will get back. Goodbye. Goodbye.
Judge Simpson